He was sentenced to die. The jury said, "Death." The judge signed the order. The courtroom believed it was over. But inside California's prison system, he's still alive. For nearly 2 decades, executions have been halted, yet hundreds remain on death row. So what does a death sentence really mean in California? Is it justice delayed, or a system frozen in time? Tonight, we step inside the truth behind California death row, where the most serious crimes meet a legal system that may never carry out its final promise. The courtroom was silent when the jury foreperson stood up. Death. One word. The families in the front row held hands. Reporters stopped writing. The man at the defense table did not move. He had just been sentenced to die under California law. But here is the twist: years later, he would still be alive. And so would hundreds of others sitting on California's death row. How does a state sentence someone to death and then stop carrying out executions? To understand that moment in the courtroom, we have to go back to the beginning of how California death row works. Back to the long road that starts with a crime and leads to a sentence that may never be carried out. California is the most populated state in America. It also has one of the largest death row populations in the country. When a person is convicted of certain very serious crimes, prosecutors can ask the jury to consider the death penalty. But it is not automatic. First, there is a trial to decide guilt. Only after a guilty verdict does the case move to a second phase, the penalty phase. In that second phase, the same jury must decide between 2 choices: death or life in prison without the possibility of parole. Life without parole means the person will never be released. They will spend the rest of their life inside prison walls. No early release, no second chance outside. Death means something else entirely. It means the state plans to carry out an execution. But in California, the process does not end when the jury speaks. It only begins after a death sentence is announced. The case automatically enters the appeals process. This is required by law. Every person sentenced to death in California receives a direct appeal to the California Supreme Court. That court reviews everything: the trial transcripts, the evidence, the jury instructions, the behavior of prosecutors, the actions of defense lawyers. They look for mistakes, legal errors, violations of rights. This review can take years, sometimes more than a decade. If the California Supreme Court upholds the sentence, the case does not end there. The person can then file federal appeals. Federal courts examine whether constitutional rights were violated. Each step can take years, sometimes decades. Meanwhile, the person waits. Most male death row inmates in California have been housed at San Quentin State Prison. The building sits near the edge of the San Francisco Bay. Thick walls, narrow windows, a separate housing unit for those sentenced to death. Women sentenced to death are housed at Central California Women's Facility. Life on death row is different from general population. Cells are smaller, movement is limited, security is tighter. Many inmates spend large parts of the day alone. But here is something many people do not realize. Since 2006, California has not carried out an execution. Legal challenges over lethal injection procedures led to delays. Courts questioned whether the method caused unnecessary suffering. The state paused executions while new protocols were reviewed. Then, in 2019, California's governor signed an executive order placing a moratorium on executions. This halted them entirely while he remained in office. That meant something historic. More than 700 people were on death row at the time, all of them sentenced to die, none facing an execution date. The courtroom promise of death had turned into something else, a sentence without a timeline. Some families of victims felt relief when the death sentence was announced. They believed it brought justice. But as years passed, many found themselves returning to courtrooms again and again for appeals hearings. Each appeal reopened old wounds. Each filing meant more waiting. Other families began to ask a painful question: if executions are not happening, what does a death sentence really mean? Inside prison walls, another question grew. What is the difference between death row and life without parole? If neither leads outside, there are key differences. A person serving life without parole enters the regular prison system. They may work certain jobs, They may join programs. They live among other inmates serving long sentences. A person on death row historically lived in a more restricted environment. Separate housing, different rules, fewer programs. But recently, California began changing this system too. In 2020, the state announced that some death row inmates would be moved into the general prison population. The goal was to allow more access to programs and work opportunities, while still keeping the death sentence legally in place. It was another shift, another layer of complexity. To understand how we got here, we have to look at the bigger picture. California reinstated the death penalty in 1978 after voters approved a ballot measure. Since then, juries have sentenced hundreds of people to death, but the number of executions carried out since that time is far smaller. Many people sentenced to death have died of natural causes while waiting. Some have had their sentences overturned on appeal. Others remain in legal limbo. The system is heavy, slow, expensive. Each appeal requires lawyers, investigators, court staff, and judges. Some inmates wait years before they are even assigned an appeals attorney because of shortages in qualified defense counsel. Critics argue the system costs millions more than life without parole cases. Supporters argue that the death penalty remains an important legal option for the most serious crimes. And in the middle of this debate are the inmates themselves. Some maintain their innocence. Some admit guilt. Some fight their appeals. Others stop filing and ask for their sentence to move forward. But even when someone waives appeals, the moratorium still stands. Executions remain paused. So what happens when a serial killer receives a death sentence in California today? The headlines explode. The courtroom fills. The jury speaks. But after the cameras leave, the case enters a long tunnel of legal review. Years pass. Governors change. Public opinion shifts. Ballot measures appear. In 2016, California voters rejected a proposal to repeal the death penalty. They also approved a measure meant to speed up appeals. Yet even with those votes, executions remain halted. So the question lingers in the air like a shadow over every death row cell. Is California's death row a waiting room, or a permanent sentence that will never be carried out? Back in that courtroom, the man who heard the word death was led away in handcuffs. Outside, reporters told the world justice had been delivered. Inside the prison gates, he was given a number, a cell, and a stack of paperwork explaining his automatic appeal. The legal machine had begun to move, but it moves slowly, sometimes so slowly that people begin to wonder if it is moving at all. And then, years after his sentence, something unexpected happened. A new legal challenge reached the courts, one that questioned not just the method of execution, but the fairness of how death sentences were applied across counties in California. Data showed major differences. In some counties, prosecutors sought death frequently. In others, almost never. The numbers raised hard questions about equality and consistency in the criminal justice system. If the ultimate punishment depends on geography, what does that mean? The challenge moved upward. Judges reviewed statistics. Lawyers argued over constitutional principles. And for the man in the cell at San Quentin, and for hundreds of others like him, the outcome could change everything. Because if the court agreed the system was unfair, it could mean new hearings, new sentences, maybe even conversion from death to life without parole. The promise of execution already paused could disappear entirely. The courtroom word, death, might transform into something else. And as the California Supreme Court prepared to consider arguments that could reshape the entire system, one truth became clear. The fate of every person on California death row was hanging on more than just their crime. It was hanging on the future of the system itself. And no one knew what the next ruling would bring. The letter arrived in a thick envelope, stamped by the court. Inside that envelope was not freedom, not release, not execution. It was something else. A notice that the appeal had officially begun. For the man sentenced to death, this was the next chapter of his life. Not days, not months, years. In California, a death sentence triggers an automatic appeal to the California Supreme Court. This is not optional. It is required. The court reviews every word spoken during the trial, every motion filed, every objection made, every instruction given to the jury. Boxes of transcripts are shipped to justices. Thousands of pages. Defense lawyers search for legal errors. Did the prosecutor say something improper? Was key evidence admitted correctly? Did the jury understand the law? Even a small mistake can matter, because when the punishment is death, the law demands extreme care. But here is the reality. The system moves slowly. Many people on California death row wait years before they are assigned an attorney for their appeal. Qualified death penalty lawyers are limited. The cases are complex. The paperwork is heavy. While waiting, inmates remain behind bars. Some read law books. Some write letters. Some sit in silence. Time becomes the loudest sound in the room. Outside the prison walls, families also wait. Families of victims. Families of the condemned. Both sides follow court updates. Both sides relive the past whenever a new filing appears. And then, sometimes, the first major decision arrives. The California Supreme Court issues its ruling. In many cases, the court upholds the conviction and the death sentence. But not always. Sometimes the court finds an error serious enough to overturn the penalty phase. That means the death sentence is removed. A new penalty trial must be held. In some rare cases, convictions themselves are overturned. When that happens, the entire case shifts again. But even when the state Supreme Court affirms the sentence, the road does not end. It moves to federal court. This is where constitutional questions come into focus. Was the defendant's right to effective counsel violated? Was evidence withheld? Was there racial bias in jury selection? Federal judges review the record again, and again, and again. Each step can take years. Meanwhile, California's execution chamber remains unused. In 2006, legal challenges over lethal injection procedures placed executions on hold. Courts questioned whether the drug protocols were consistent with constitutional standards. The state attempted revisions. More litigation followed. Then came 2019. Governor Gavin Newsom announced a moratorium on executions. He ordered the dismantling of the execution chamber at San Quentin. No executions would occur during his time in office. The death sentences remained legally valid, but no one would be put to death. This decision changed the emotional weight of every appeal. Before the moratorium, appeals could eventually lead to an execution date. After the moratorium, the future became uncertain. Was death row still a path toward execution? Or had it become something closer to life without parole, but under a different name? For some inmates, the difference matters deeply. Life without parole means they join the general prison population immediately. They can work jobs, participate in programs, earn small privileges. Death row historically meant tighter security, fewer programs, more isolation. But California began adjusting that too. In recent years, the state moved many death row inmates into the general population system, allowing more access to programming while keeping the sentence intact. Another shift, another change, and yet, the appeals continue. Legal scholars often describe California's death penalty system as one of the most complex in the nation. It is also one of the most expensive. Studies have shown that death penalty cases cost significantly more than life without parole cases, due to extended trials and decades of appeals. Critics argue the system is broken. They point to the long delays, the uneven application across counties, and the fact that no executions have occurred in years. Supporters argue that the death penalty remains an important tool for the most serious crimes. They believe appeals are necessary but should move faster. The debate moves through courtrooms, legislatures, and ballot boxes. In 2012, California voters rejected a measure that would have ended the death penalty. In 2016, voters again rejected repeal but approved a measure aimed at speeding up appeals. Even so, the pace remains slow, and for the man sentenced earlier, years have now passed. He has watched other inmates receive rulings. Some have had their sentences reduced to life without parole. Others remain in the same position he is in, waiting. The uncertainty becomes its own kind of sentence. He once believed the word death meant a clear ending. Now, he understands it means something else. Legal battles, paperwork, years of silence between decisions. But then, something unexpected begins to unfold. A group of attorneys files a broader constitutional challenge. They argue that the extreme delays themselves make California's death penalty unconstitutional. Their reasoning is simple. If a person waits 20, 25, even 30 years for an execution that may never happen, is that consistent with the idea of justice? Some federal judges begin to examine this question seriously. In one case, a lower court judge ruled that the long delays rendered the death penalty system arbitrary and dysfunctional. The decision was later overturned on appeal, but the argument did not disappear. It remains in legal discussions. It remains in court filings. It remains in the minds of inmates and families alike. Because if a higher court ever agrees that the delay itself violates constitutional standards, it could transform every death sentence in California. Back inside the prison, the man receives another letter. This one is different. His federal habeas petition has been accepted for review. It means more waiting, more arguments, more years, but it also means something else. His sentence is not final, not yet. And as California's political climate continues to shift, new governors may one day make different decisions about the moratorium. Executions could resume, or the state could move toward permanent repeal. The system stands at a crossroads. In courtrooms across California, prosecutors still seek the death penalty in certain cases. Juries still return death verdicts. The law remains on the books, but the execution chamber sits silent. For now, and then, just as many believe the system would remain frozen indefinitely, a new legal development emerges. A statewide review begins examining whether death row housing conditions violate evolving standards of decency under constitutional law. If the court finds the conditions unlawful, it could require massive restructuring, possibly even resentencing. The news spreads quickly. For the man in the cell, and for hundreds of others, this review could change everything. Because if the housing system tied to death row collapses, what happens to the sentence attached to it? Will death row as it exists today survive? Or will California's entire capital punishment structure be forced into a new form? As judges prepare to hear arguments that could reshape decades of policy, one truth becomes clear. The sentence spoken in that silent courtroom years ago is still echoing, but its meaning may not be what anyone thought it was. The execution chamber at San Quentin sits quiet. The room is still there. The gurney, the straps, the witness area separated by glass. But dust gathers. No footsteps echo down the final hallway. No last meals are prepared. The system that once carried out executions now stands paused like a clock that stopped ticking. And behind thick prison walls, more than 600 men and women live with a sentence that says, death, in a state that does not carry it out. This is California death row today, a place caught between law and reality. When someone receives life without parole in California, the meaning is clear. They enter the prison system. They may work in kitchens, libraries, or maintenance. They can join education programs. Some mentor younger inmates. Some earn small privileges over time. They will never walk free, but they live inside a system designed for long-term incarceration. Death row was built differently. For decades, men sentenced to death were housed separately at San Quentin. They lived in single cells. Movement was tightly controlled. Recreation time was limited and often alone. Security was higher. The label carried weight. Yet as the years passed and executions stopped, questions grew louder. If no execution date exists, why maintain a separate system? In 2020, California began transferring many death row inmates into the general prison population. The state said this would allow access to programs and jobs, while keeping the death sentence legally intact. For some, it was a major shift. Men who had spent years in isolation-like conditions suddenly found themselves in regular housing units. They could attend classes, work small jobs, speak more freely with others. The sentence did not change, but daily life did. Still, the word death follows them. Every file, every record, every appeal carries that label. And appeals continue. Some inmates have now waited more than 20 or 30 years for their cases to move through courts. Some have died of natural causes while waiting. Their death sentences ended not by execution, but by time. For families of victims, this reality is complicated. Some believe the death sentence would bring closure, but closure delayed can feel like closure denied. Each appeal filing can reopen wounds. Each hearing can bring painful memories back into public view. Other families have said the endless appeals create uncertainty that never ends. They ask, would life without parole have been simpler? On the other side, families of those sentenced to death often speak of hope during appeals. Hope that a legal mistake will be found. Hope that a sentence will be reduced. Hope that life without parole will replace death. This tension sits at the heart of California's criminal justice system. The law still allows death sentences. Juries still return them in certain cases. Yet the governor's moratorium blocks executions. The state legislature has debated repeal. Voters have rejected ending the death penalty in past elections. Public opinion remains divided. Meanwhile, the legal machine keeps turning. Each new death sentence automatically joins a long line of appeals. Each appeal adds to a backlog. Some legal experts argue the delays themselves raise constitutional questions. Is a punishment still meaningful if it may never be carried out? Others argue that the careful review process protects against wrongful executions. Because once carried out, an execution cannot be reversed. California's history includes cases where convictions were overturned years later due to new evidence, including DNA testing. Those reversals remind courts why appeals matter. Inside prison, daily life continues. Morning counts, meal lines, yard time, law library visits. For a man sentenced to death, routine becomes survival. Some focus on appeals. They study case law. They write to attorneys. Some withdraw. Some express remorse. Some maintain innocence. Every story is different, but all share the same uncertainty. Unlike life without parole, which carries a clear ending, prison until natural death, a death sentence in California carries a question mark. Will executions ever resume? If a future governor lifts the moratorium, would the state restart the process? Legal experts say it would not happen quickly. Years of litigation would likely follow. Drug protocols would face scrutiny. Court challenges would return. Even if the moratorium ended, the path to execution would still move slowly. And then there is the financial question. Studies have estimated that California's death penalty system costs far more than life without parole cases, largely due to lengthy appeals. Taxpayers fund the courts, attorneys, housing, and review process. Supporters argue justice for the most serious crimes is worth the cost. Opponents argue the money could be spent elsewhere within the criminal justice system. The debate stretches beyond prison walls. It reaches ballot measures, campaign speeches, and community meetings. But inside the cell, the debate feels distant. There is only today, and tomorrow, and the next court date. If all appeals fail, his sentence remains death. But as long as the moratorium stands, there is no execution date. If a court overturns his penalty phase, he could be resentenced to life without parole. If lawmakers repeal the death penalty in the future, his sentence could automatically convert. So what does death mean in California today? Legally, it remains the most severe punishment available. Practically, it has become something closer to permanent legal uncertainty. A sentence that exists on paper, a system paused in action. The execution chamber waits in silence. The appeals courts remain busy. The prison gates stay locked. And the question that began in that silent courtroom still hangs in the air. Is California's death row a path toward execution, or the final chapter of a system slowly changing into something else? As the sun sets over San Quentin's old stone walls, the bay water moves quietly below. Inside, hundreds of men live under a sentence that says their lives will end by the state. Outside, the state has chosen for now not to carry it out. The story of California death row is not one of a single verdict. It is the story of a system in limbo, a system balancing justice, law, cost, fairness, and time. And until the law changes or the moratorium ends, the words spoken in that courtroom will remain suspended between two realities. Death on paper, life behind bars. Waiting. If you're interested in real-world criminal investigations and documentary storytelling, follow for more in-depth true crime analysis.